Morning, everyone, and welcome to our Beasley Allen webinar program, Automotive Class Actions and Securities Fraud. On today's program, my partner James Eubank and Mitch Williams will explore the complexities of two specific class action lawsuit types, auto defects and securities. James and Mitch are going to break down effective strategies for navigating these complex fraud cases, and they'll give you the tools that you need to identify the fraudulent schemes that impact our most important and valuable assets. While we're waiting on the last of our registrants to join us, I want to take just a few moments to formally introduce our two distinguished speakers. First, my friend and partner James Eubank is a longtime member of Beasley Allen's Consumer Fraud section. James specializes in cases involving bank fraud, insurance fraud, and violations of the Employee Retirement Income Security Act, or ERISA. Prior to joining the firm, James worked as an associate counsel and assistant attorney general at the Alabama Securities Commission, where his work included prosecuting criminal cases in all state and federal courts across the state. He filed civil and administrative actions, and he advised the commission on current legal issues. James has also served as a special assistant United States attorney in the Northern District of Alabama, where he's prosecuted cases involving securities fraud, wire fraud, and mail fraud. In addition, James worked as a senior deputy district attorney in Montgomery County, where he helped prosecute over 30 criminal jury trials and 20 criminal and civil bench trials. James is a huge asset to our consumer fraud section at Beasley Allen, and we're just so happy to have him here with us today. Next, Mitch Williams is another member of our consumer fraud team at Beasley Allen. Mitch specializes in product liability class actions, and his cases involve some of the biggest manufacturers in the world. Folks like Nissan, Toyota, Honda, Subaru, Mazda, Ford, General Motors, Hyundai, Kia, Mercedes-Benz, Volkswagen, Caterpillar, and numerous other original equipment suppliers. Mitch helps the team lead discovery and litigation strategy in those cases, and he's got a real knack for quickly making sense of those complex component and system issues that arise in those type cases. We're delighted to have Mitch Williams on our team, and we look forward to hearing from him today on what I think is a really important litigation topic. So, before I turn the program over to our speakers, I need to go over just a few CLE housekeeping notes. Today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. In order to receive full credit for attending, you've got to stay on for the duration of today's program. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered. But by the end of this week, you're going to receive another email with a certificate of attendance and an updated presentation and video link. You can email your completed evaluation form to webinars@beasleyallen.com. This webinar is being recorded, and for those Alabama and Georgia attorneys participating today by phone, please email us your name, phone number, and state bar ID numbers to webinars@beasleyallen.com. That's going to help us ensure that you receive full CLE credit for today's program. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we're going to be adding more webinars throughout the year. And you can access our webinars on demand anytime you like on that same webpage. Finally, if you've got questions during today's webinar, I want to encourage you to use the question and answer feature located at the bottom of your screen. Take a moment to check out, find that button. It's the Q&A button at the bottom of your screen. We're going to set aside time at the end of today's program to try and tackle all of the questions submitted by our viewers. So with that, James, Mitch, I'm going to turn it over to you, and let's get started.
Thank you, David. Good afternoon, everyone. As David said, my name is Mitch Williams, and I'm an attorney at the Consumer Fraud section here at Beasley Allen. My practice mainly focuses on automotive class actions, though I also represent businesses such as farming and logging companies in litigation against other manufacturers for defects in the heavy equipment that they make. If we can pull up the PowerPoint real quick, there we go. So we all know what a class action is. I'm not going to sit up here today and tell everybody what a class action is and go over Rule 23. We've done that extensively in other CLE webinars. Today, though, I want to kind of do a deeper dive into some unique issues related to automotive class actions and consumer class actions in general, and cover the heightened pleading standard required in class actions. I want to cover that today, and then in future webinar CLEs, we plan to do a deeper dive into other issues unique to automotive and consumer class actions. So, like other areas of tort law that we all practice, automotive class actions and consumer class actions in general are under attack. These are through things such as arbitration, which prevents individuals from having their day in court, ineffective recalls that leave consumers without a remedy due to judicial doctrines preventing their mooting out their claims. It's also related to heightened pleading standards above and beyond what the rules require. And if you make it through discovery and the motion to dismiss practice, when you ultimately get to class certification, there's a host of individualized issues that could prevent certification, such as damages, manifestation, reliance, and a whole new list that comes out every day. I could spend hours talking about each of these, like I said, and in the future we will dive deeper into those other issues. But today I just want to focus on the heightened pleading standards automotive and consumer class actions are held to. We'll go to the next slide, please. So by way of background, automotive class actions are fraud and warranty based. The fraud claims include state Consumer Protection Act statutes and common law fraud, and they are based on the premise that the defendant knew about a defect but did not disclose it before the plaintiff purchased the product. The warranty claims are based on the implied warranty of merchantability, and they're primarily focused on the premise that a product with a safety defect was sold by the defendant, who is a merchant, and that defect makes the product unfit for its ordinary purpose. One note real quick before we move on about the fraud claim. In our experience here at Beasley Allen, successful consumer class actions are premised on omission theories, not misrepresentation theories. That's because misrepresentation theories require you to allege and ultimately prove that every single class member reviewed and relied on the same marketing. That's easy to do when your class action is based off of the packaging of a product. In that case, everybody saw the same packaging and they relied on the fraudulent nature of the packaging. But when cases such as consumer products with automobiles or lawnmowers or other mass marketing and not individualized packaged products, that's hard to prove. So what we do and what we found to be successful here is to style them as omission cases. These don't require you to identify specific statements that were made. Rather, it requires you to show that in every communication the defendant made to the consuming public, that it never disclosed the defect. Let's go to the next slide, please. Thank you. So I think a common misconception after talking with attorneys all over the state of Alabama and in Georgia and really all across the country, if you don't practice automotive class actions, you think that they're nationwide. You think that one or two plaintiffs in some ideal states are representing everybody across the country. And that's just not true. As we said in the previous slide, consumer class actions are based on states' laws, individual states' laws. There's not a federal statute by which you can hook a nationwide class on. So if you want to, the more map you want to cover, you have to have plaintiffs from each state. So for example, a plaintiff in Alabama can only represent other Alabama class members. You have to have a plaintiff from Georgia and Pennsylvania and the remaining 49 states in order to cover the full map. Now, there are some workarounds. The Maximus Warranty Act is included in probably every single consumer class action complaint that's filed, although we've quit alleging it in our case because the law is pretty well developed that, one, it's not an independent cause of action. It's not an independent federal cause of action. It's dependent on states' warranty laws. And also for a class action, it requires 100 plaintiffs. That raises a lot of manageability issues, and most class actions don't have anywhere close to 100 plaintiffs. So the Magnuson-Moss Warranty Act has no teeth. People still try to use it to get a nationwide class as a hook. We've quit doing that here for the reasons discussed. Another thing folks do, and we do here, is multi-state claims. The argument there, the theory there is that you can group like statutes. So you can group consumer fraud statutes that don't require reliance or scienter, separate from consumer fraud statutes that do require reliance and scienter. And the thought is, if you group them and you have one plaintiff who can represent each group, then they should be able to represent other states in which they don't live or they didn't, as you see, purchase the product. It's a mixed bag, like I say. Defendants always move to strike those at the motion to dismiss. Where we've been successful to get in getting the judge to delay the ruling on that until class certification, and we don't yet have a ruling on that. I can speak from experience of reading other cases where it's a mixed bag, like I say here. Some courts aren't interested in entertaining that. They don't have much of an opinion on why they're striking the multi-state claims. And other courts say that after they've evaluated the individual elements of each state, that they just can't be grouped as simple as this. On the other hand, there's other cases where the courts have accepted multi-state claims. So based on that, we include them in our cases, and we encourage other people to include them in their cases as well. An issue that often arises in class actions is which state law applies. The easy question is, if you have a plaintiff who lives and is domiciled in Alabama, they purchase a vehicle in Alabama, they drive in Alabama, they experienced a defect in Alabama, and they had it repaired in Alabama. In that case, it's easy that the Alabama law applies. But what about if you have a plaintiff who lives in Gulf Shores, Alabama? They bought their vehicle in Pensacola, Florida, and more to the facts, they live in Alabama, they drive in Alabama, they experienced the defect in Alabama, they had the defect repaired in Alabama, but they bought the car in Florida. So which law applies? Well, there's different approaches. If you can remember back to conflicts of law in law school, there's two different approaches, but there's usually one outcome under those approaches, at least in the consumer product context, and that's you apply the law of the state where the product was purchased. That's because these are point of sale cases. The theory is that the plaintiff was defrauded at the point of sale. The defendant failed to disclose a defect about which they knew, and had it been disclosed, the plaintiff would not have purchased the product. So you're damaged at the point of sale, and you have to apply the law of the state where the product was purchased. Next slide, please. Another hurdle to consider before drafting your complaint, and something we consider with every case that we file, is obviously where to file your class action. The law on personal jurisdiction and class actions changes all the time, especially in light of the Supreme Court's 2017 opinion in Bristol-Myers Squibb. In that case, the Supreme Court essentially held that if you don't sue a defendant at their home state where they're subject to general jurisdiction, that only plaintiffs who live in that state can sue the defendant. So that obviously causes hurdles. In our business, you don't want to file every case in Michigan. But we research this at every time we file, because like I said, it's an ever-changing area of the law. And hopefully one day with the right lawyer and the right judge, we'll get some good rulings. But right now, the trend is the courts are holding that BMS does apply to class actions. So like I said, that requires you to file your class action in the state where the defendant is subject to general jurisdiction. For the most part, in the automotive context in which I practice, that just so happens to mostly be Michigan. I want to point out one thing here in the last bullet point. If you look into this in any level of detail, you're going to see some cases saying that they defer this analysis until class certification. I think when you read those in closer detail, the courts are confusing the personal jurisdiction and the standing analysis, and they're citing Bristol-Myers Squibb for that. But what those courts are really saying is that for absent class members, unnamed plaintiffs, you can defer the standing analysis until class certification. But ultimately, at the motion to dismiss stage, each plaintiff, as the law has always been, each plaintiff must establish personal jurisdiction over each claim. And unfortunately, in light of BMS, unless you're filing in the defendant's home state, you can't establish that. Next slide, please. So now, when you draft your complaint, there's a lot of things to consider when in the automotive and consumer class action context. The normal rules, the normal Rule 8 and Rule 9 don't necessarily apply. There's an entire body of case law that sets even stricter and heightened pleading standards for consumer class actions. And I'll point those out as they come out. But right now, I kind of want to show you each what our complaints look like. We have a section in each complaint where we have a standard intro, the parties, the jurisdiction and venue. But then when we get into the factual allegations, we have a designated self-heading for each required element, either from our substantive law, Rule 23, or the pleading requirements. So the first thing we'll have our factual allegations, like I said, but in between the factual allegations and the causes of action, we'll have a section called who, what, when, where, and how. And the reason for that is because these are fraud cases. Rule 9b does apply. And under Rule 9b, as we all know, you have to allege with particularity the fraud. Okay, so the case law interpreting that says who, what, when, where, and how. So what we'll do is we'll have a designated section where that's the title, and we'll have a paragraph for each. So, for example, in a GM case we have a case against General Motors that was actually successfully tried to a verdict in California 1 year ago to the date of today. But anyway, in the complaint there, we have a designated section that says who in bold and italicized, and then we say GM, its subsidiaries, its agents, and all the other legal jargon you throw in there to preserve other employees who could be working for GM or other actors who could be working for GM. And then we'll say what? GM failed to disclose the piston ring defect. When? At the point of sale or any time thereafter. Where? In all of its communications with plaintiffs and the public. And how? By failing to disclose the defect. Now, this seems redundant, and it really is redundant, but this is a really good practice that we use and that we recommend other people use to make sure that it's explicitly laid out in your complaint who, what, when, where, and how. Another thing to point out, not necessarily something to put in your complaint, but will be raised on a motion to dismiss by the defendants, and that's you didn't allege the content of an omission with particularity. Well, fortunately for the plaintiffs, the case law relaxes that particularity standard for omission cases to the extent that it requires you to identify the time, place, and content of something that was never said. So the defendants will always raise that, but just be aware that there's good case law on your side that says you obviously cannot identify the substance of something that was never said. Another thing you have to include in your complaint, and this is probably the most important thing to include in a complaint, and probably the harshest rule that's applied to class actions that's not applied to other cases, and that's when it comes to knowledge. Rule 9b, by its plain language, says that knowledge can be alleged generally, but in the class action contents, generally means specifically. The case law states that your allegations have to be specific enough to support an inference that the defendants actually knew about a defect. Okay, and it's the actually knew part that throws a wrench in everything. And it's most likely going to be the reason if your case gets dismissed, that's going to be why. And so we have 5 ways we look at when we're investigating case to determine whether we can allege knowledge. The first thing is TSVs and recalls. Now these could cause other issues in your case down the road, and we'll discuss those. But in terms of the knowledge requirement, TSVs and recalls are an admission from the defendant that they have a problem. It's a public acknowledgement of a defect. And you can plausibly allege that the defendants actually knew about it because those are their statements. And there's good case law that supports that holds knowledge reasonably predates the issuance of a TSV or a recall. And in fact, some case law suggests that it goes back 2 years. So if you can find a TSV or a recall acknowledging a defect in the case that you're trying to file, you can use that as an anchor for knowledge 2 years from the date it was issued. So always look for TSVs and recalls. They're a really good source of knowledge in your complaints. The second thing we look for are NHTSA complaints. The National Highway Traffic Safety Administration collects and aggregates tons of consumer data and complaints from consumers in the field. They sort these, they keep these and maintain these in a database identified by the model of the vehicle, the model year of the vehicle, partial VIN, and then they further put them in a database by what's called tread codes, and these are codes related to components and systems of a vehicle. Under federal law, manufacturers have a duty to monitor and monitor trends and monitor those NHTSA complaints. So under federal law, you do have a plausible reason to allege that the defendants have actual knowledge of NHTSA complaints. Now, the issue with NHTSA complaints is how many is enough? One's not enough, and hundreds probably not required. I don't have a good answer for that. There's no clarity from the case law. I think our practice here at Beasley Allen is 1 to 20 is not enough. 20 and to probably 40 or 50 is enough if you have other sources of knowledge, and then anything above 50 by itself is probably a good amount of NHTSA complaints that can support knowledge in your at the pleading stage. Another source of knowledge we look for are forums. Now, this one is a little troublesome because it's hard to plausibly allege under Rule 11 that defendants monitor third-party forums. However, sometimes you can get lucky. For example, we have a case against Ram. It's against FCA, who makes Ram trucks. And Ram truck owners are very passionate truck owners, and there's a lot of online forums about those trucks. The owners are chatting about our defect. It's a defect where related to the e-torque, the hybrid trucks, where these are just spontaneously shutting down during normal operation on the highway, leaving the highway, turning at an intersection, leaving a parking lot, all different driving situations. These vehicles are stalling and coming to a complete stop. Well, we found a lot of chatter about that, as you would expect, on forums. Not too many NHTSA complaints because these are brand new models and model years, so there weren't too many NHTSA complaints, although there were some, but there was a lot of chatter on forums. Well, the law usually doesn't allow forums to apply. You can't usually rely on forums to raise an inference of knowledge of the defendant, but in that case, Ram operates a customer support account on that forum called Rams Cares. And so when you read the forums and you see that the defendant actually has an account on that forum and is monitoring it, well, then obviously you can plausibly allege that they do monitor and are aware of those complaints. So we were able to use those in the complaint to support an inference of knowledge. I haven't seen too many more manufacturers doing that. It's only been with Ram, but that's something to pay attention to when scouring the internet looking for sources of knowledge. You're always going to find a good forum. Take the time, read every page in the forum, because you never know if you're going to see a Rams Cares account or a GM Cares account commenting and saying, please contact us at this number. We'd love to help you. Another source of knowledge, this is a new one we do, is warranty data. Obviously, all manufacturers track warranty data. It's just impossible for us to know what the warranty data is without discovery. What we've done, though, is we've tracked all the recalls historically. And when a manufacturer issues a recall, they have to identify how many field complaints they received and how many warranty claims they have. So we've tracked those for each manufacturer over time. And what you see is that they have 50 field complaints and 5,000 warranty claims. And then we further analysis and also looked up how many NHTSA complaints we could find on that same issue. And let's say we found 10 to 15 to 20 NHTSA complaints on that issue. Well, then when you do that over a period of time and put it in a spreadsheet that you can attach as an exhibit, you can plausibly allege that for every one NHTSA complaint, there's hundreds or thousands of warranty claims received by the defendant. We don't know what that total number is here, Your Honor, and it's what you would say at motion to dismiss. But we do know that traditionally they did receive that volume of warranty claims based off a low volume of NHTSA complaints, and so it's a reasonable inference that they received this, that the same is true here. We've been doing that in our past 2 or 3 complaints. We don't have a ruling on that yet, but I do know that at the hearings the judges were receptive to that. It's different than just conclusively alleging that defendant receives warranty claims. They knew about it from the warranty claims. I don't have the warranty claims because I don't have discovery, but once we get there, I'll be able to prove knowledge. The judges don't buy that. They strike those out of your complaint. It's not a well play, it's conclusory. But this one causes them pause. And so we'll see. I think that'll be a new avenue to start alleging knowledge. Another thing that we include in every complaint, and it in of itself is not enough for knowledge. It's testing. Obviously, defendants and manufacturers do extensive pre-release testing of their products, and during that testing, things happen. That's the point of testing. So we always allege that, you know, they did perform such testing and that they learned of the defect or the possibility of the defect through that testing, but we don't have those results, and only discovery will bear that true. Courts, like I say, aren't too receptive to that, at least in and of itself. If you include a testing allegation along with, you know, 30 NHTSA complaints and some warranty data, that combination of those maybe enough to satisfy the knowledge requirement, but the testing in and of itself will not be. Moving to reliance. Reliance is the big issue, not necessarily at the pleading stage, but it'll be the big issue throughout the rest of the litigation. It's easy to allege reliance. It's just something people often forget to do. Our practices, we say this exact language in every cause of action and then in every plaintiff's factual allegations above. We just say plaintiff and the class members would not have purchased the product or would have paid less for it had the defect been disclosed. As long as you're basing your fraud on an omission-based theory of fraud, those allegations will do. Next page, please. Next slide, please. Materiality is a huge thing. Defendants only, you know, this is omission, so you have to essentially prove and allege a duty to disclose. In most states, there's a duty to disclose material safety defects or material information, and materiality in the automotive class action context is satisfied through safety defects. Now, we've talked about safety defects in prior CLEs and webinars, but I want to kind of, you know, explore that a little bit here, because safety defects obviously are if your brakes fail, like in our F-150 case, that's the partial brake failure. That's obviously a safety defect. But there's lesser things that can be a safety defect too. For example, our GM case is an engine defect. Defective piston rings cause excessive oil consumption, which damages or destroys other engine components and potentially leads to a stall. That is a safety defect. Defective fuel pumps, where they fail to deliver fuel to the engine, and therefore it causes hesitated acceleration, stalling, or failure for the engine to start. That's a safety defect. There's new driver technologies where they detect a vehicle, for example, the ADAS stuff, the AEB braking, automatic emergency braking. Nissan has it. We have a case against Nissan on that technology. That technology is supposed to detect a collision before it happens and apply the brakes to either prevent the collision or to mitigate the effects of the collision. In the Nissan case, however, it detects obstacles that are not there and spontaneously applies the brakes in just normal vehicle operation on highways, intersections, parking garages, and even just regular parking lots. That's a safety defect. But the courts have also found that safety defects can be related to rear view cameras. If you rely on a rear view camera and the screen is black, that's a safety defect. And also infotainment systems. If there's a defect with an infotainment system, Bluetooth, navigation, other systems under the infotainment umbrella, if there's an issue with those, that too can be a safety defect. And that's mostly because of the distraction to the driver. It doesn't affect vehicle operability, but it distracts the driver while they're operating the vehicle. And so those are what you really need to look at when you're considering, is this a safety defect, and how to frame it in your complaint. It's a safety defect because it either impairs vehicle operation or distracts the driver while they're operating a vehicle. And you need to lay it out in your complaint that way. And not only do you need to explicitly allege how it's a safety defect and the consequences it can cause in your complaint, but you need to give the court some examples, because in the Sixth Circuit, it's not enough just to allege that it's that these things can happen. You have to give proof that it is happening and that the defendant knew about it. And again, just like with knowledge, we do that with NHTSA complaints. If somebody's vehicle stalls at an intersection, you can be sure you're going to find a NHTSA complaint on that. It's easier to find NHTSA complaints on people stalling than it isn't, unfortunately. So you need to be sure that you go out and identify all complaints and other sources, other publicly available sources that you can put in your complaint to support an inference that this is a safety defect. The next one is pre-suit notice. Oh yeah, there we go. Pre-suit notice. This one is something that just needs to be said to everybody all the time. The consumer fraud statutes, about half of them across the country, require pre-suit notice. There are varying degrees of time. In Alabama, it's 15 days. Texas, it's 60 days. California, it's 30 days. You just need to research it, because you have to send pre-suit notice. And not only do you have to send pre-suit notice, in a lot of states, you have to explicitly allege that you gave pre-suit notice and attach it as an exhibit to your complaint. And it's very important to do that, because if not, some courts hold it's jurisdictional. So if you fail to do it, they don't even have jurisdiction over the claims. But it's just too easy for the defendants to have your case tossed out at the motion to dismiss because you failed to give pre-suit notice, when it's just a letter, just drafted on day one after you retain after your client retains you and you have enough information to send the letter. Let it start to mature while you prepare your complaint. You don't have to wait for a response. You don't have to go back and forth with the response. Send the letter. They're going to ultimately respond, and then just ignore it. Then you can file your complaint. Although I'm preaching send notice, I just want to point out that there are some exceptions to notice. Okay. Some states will, you don't have to send notice if the defendant has actual knowledge of a defect. So depending on how strong your knowledge allegations are, as we discussed earlier, you may be able to rely on that if you somehow failed or forgot to send pre-suit notice. In other states, Alabama being one of them, you don't have to send notice if the defendant does not own property in the state. So we still try to send notice in every case for every cause of action, because it's a good practice. But like I said, if you forgot or just failed to send notice when you're responding to the motion to dismiss, just make sure you read the statutes and the relevant case law, because there could be some exceptions. Next slide, please. All right, so we're moving over now into the implied warranty of merchantability. This one is much easier to plead because you don't have the notice, you don't have the Rule 9 requirements. That's another thing to keep in mind when you're defending, when you're opposing a motion to dismiss. Don't let the judge hold you to your implied warranty of merchantability claim to the Rule 9 standard. That's a Rule 8 standard. We can be more relaxed on how we allege that, although it's our practice to lay it all out. It's our practice to be a little bit over-inclusive in a class action complaint, because you want your judge to have a good feeling about your case when they're reading your complaint. And it also gives you more stuff to rely on when opposing the motion to dismiss. But for the implied warranty of merchantability, obviously, you have to allege that the defendant is a merchant, that the products are goods, and that they were purchased in the contract for the sale of goods. That's just easy stuff that you include in your cause of action. You have to allege that it's unfit for its ordinary purpose. Now, I want to talk about this for a moment, because the defendants always want to say, well, fit for its ordinary purpose in the vehicle context means it provides transportation. And so a vehicle like our F-150 case, for example, like I said, it's partial brake failure. Ford wants to always say that, no, that's not it's fit for its purpose, because even if half your brakes fail, you can still come to a complete stop. It's just longer stopping distances, and sometimes triple to quadruple those stopping distances. But that's not what the law requires. The law requires it to be safe and reliable transportation. And so if there's a risk that your brakes could fail at any time and an intermittent defect, there's a risk that they could fail, then that's not reliable. Risks and brake failure is not reliable transportation. That's what the law holds, and just be aware of that. The real thing to be aware of in your complaint for the implied warranty of merchantability is privity. Some states require privity, some states don't. For the states that do require privity, what we do is we have an independent section in our complaint. We'll call it privity, or we'll call it something else, but we establish agency allegations and third-party beneficiary allegations. So we'll talk about the agency ones first. And we have probably 15 pages of agency allegations, and these are things related to, Ford requires its dealers to display its logos. Ford requires its dealers to purchase its replacement parts exclusively from Ford. Ford requires its dealers to do X, Y, Z. There's tons of things Ford requires its dealers to do. And if you can find our complaints on Pacer. If you putting a complaint together where you want some allegations like that, just send me an email. I'll be happy to send it to you. It's easier than going over them now. But I just really want to point out the importance of including that in your complaint, explicitly laying out the agency allegations. It's not something you naturally think of when you're drafting just an implied warranty count, but you don't have privity with the manufacturer, you have privity with the dealer. So to the extent that the state requires privity, you have to have some arguments around that. And it's the same thing with third-party beneficiary. Third-party beneficiary, it's pretty easy to lay it out. The case law supports, it's pretty clear and supports the fact that warranties benefit the end user, not the dealership. In fact, if you read the language of the warranties, it says it applies sometimes to, the ultimate purchaser or the consumer. So that, include those allegations in your complaint. That way you can allege that your client and the rest of the class are the intended beneficiaries of that warranty, and then they were known intended beneficiaries at the time that the contract was made. Want to point out notice again. The UCC does require notice. Like I said, they have a strong exception for actual knowledge, but again, we don't rely on that. It's our best practice. It's best practice, and it's our practice to just send notice before you file your complaint. Next slide, please. I'm not going to go over this one a lot. This is going to be an entire topic of a future CLE. But on this one, I just want to point out, since we're talking about what to include in your complaint, a recall or a TSB could moot out your claims. We don't, here at Beasley Island, we don't want to discourage recalls. We don't want to discourage consumers from fixing their products. That's what we do here. The problem is that manufacturers issue half-hearted recalls or half-hearted TSB repairs. And so it's in those cases that you have to go through, you have to explicitly allege that the recall is inadequate, either in scope or that the repair is inadequate. We do testing. We hire an expert in all of our cases. We do pre-filing testing here, so we can include those allegations in our complaints to overcome the prudential mootness arguments. Another thing that comes with the flip side of the prudential mootness argument is that we've issued a recall. Sure, you've alleged that it's inadequate, but your client hasn't had the repair done, so their claims aren't right. That's why it's always our best practice when a recall comes out and our client contacts us about it, we tell them to get the fix immediately. Another thing I want to point out, Georgia recognizes a negligent recall claim. It's an independent cause of action in Georgia for inadequate recalls. So obviously, if you have a negligent recall claim, there's nothing to be mooted out there. So if you're practicing in Georgia, or if you're including a Georgia class, keep that in mind for a future complaint. Next slide. And this is the last one, and then I'm going to pass it over to James. You just have to include in your complaint. It's something that class actions have been tossed out before in the case law, because you have to explicitly allege the Rule 23 requirements in your complaint. You have to allege numerosity, commonality, typicality, adequacy, the predominance requirements, as well as manageability and ascertainability. It's not hard to allege that. They're boilerplate allegations, but they have to be included. If not, you could waive your chance to move for class certification in the future. Another thing you have to do in product defect cases is allege and ultimately prove that the products are substantially similar. This doesn't require the products to be identical. It just requires that the relevant defective components within the product be identical. So it doesn't, like, for example, our F-150 case, come back to it. Those master cylinders are installed in F-150s with 2 different engine packages and as well as the SUVs. Well, they're all substantially similar because the master cylinder is the defective product, and those are all substantially similar. So it doesn't have to be the entire product that has to be substantially similar. It just has to be the relevant defective component that is substantially similar. And how we allege and ultimately prove that, it depends on what the case is. If it's a design defect case, that's the easiest. You just identify the part number and say every vehicle with this part number is substantially similar. If it's a manufacturing defect, it's a little different. You just have to identify the factors that contribute to the manufacturing defect, and then figure out and allege that all the vehicles made with those factors are defective. So with that, I've definitely gone over the time that I planned to go, and I'm going to pass it over to James, who's going to talk about securities.
Hey everybody, we'll be moving through the securities portion pretty quickly. So kind of a little bit of a curveball for the introduction. We're going to discuss a little bit about securities fraud class actions, but a lot of this is actually going to focus on other investment fraud, securities fraud that you may come into, and kind of how to evaluate those cases that don't qualify really as what people normally think of as a securities class action. People's first thought is usually stock drop suits. The big things where the SEC may file an action, and some of these national securities firms may also file an action. Those are usually under Rule 10b-5, and that's the employment of manipulative and deceptive practices in connection with the sale of a security. Most always, these are publicly traded companies, and the PSLRA, which is the Private Securities Litigation Reform Act, which was passed in 1993, controls these. It includes heightened pleading standards, and it also has a process by which the lead plaintiff will be selected by the court, and almost always that's going to be the person with the largest financial stake, which is the biggest loser on the investments. That's why a lot of times in the securities fraud cases you see, the plaintiff in the reported case will often be something like the sheet metal workers pension fund or something of that nature, or potentially even state pension funds or policemen's pension funds, because often those pension funds will buy large blocks of a publicly traded security, making them a shoe-in to get lead plaintiff if they are part of the case. The elements would be manipulation or deception through misrepresentation or omission of a material fact that's in connection with the purchase or sale of securities, and there has to be scienter. Obviously, you cannot manipulate or deceive somebody if you don't intend to. So the 9B heightened pleading requirements that Mitch went over equally apply to securities fraud as well. Again, these are the things people typically think of. HealthSouth, Enron, and then Sam Bankman-Fried there with FTX are kind of your classic securities fraud cases. Securities class actions in 2022, there were 105 settlements that totaled $3.8 billion. I put the median amount of 13 million up there to show you that it kind of gets skewed by some of the larger settlements that come up. In 2021, it was 87 for 1.9 billion, and the 10-year average is 79 settlements per year for about 3.9 billion. So you can see that last year was a big year in terms of the numbers of settlement based on the averages, but about in line with the total amount. And I put the source up there if you want a screenshot, or we'll send these slides around too at the end. This securities.stanford.edu is a great resource to look for information on nationwide securities class actions. And I suggest if you want to do some research on it, that's a good place to start. But it's not only these large securities fraud actions that happen where people lose money, where you may have people come in the door in your practice and tell you that they've been a victim of some investment fraud. When you look at the FTC's data, you can see that miscellaneous investments and advice that category of fraud has been rising steadily throughout the last few years. And that's not including stock and commodity and futures trading. That has stayed pretty constant, but these other forms of investments, fraud is on the rise in those. And a lot of people will typically refer to those as private placement investments. That will be somebody has a company and they're seeking some type of a limited number of investors, but it's not something that's publicly traded. And it's not always in the form of a stock or a bond. There could be an alternative offer that's not classified as a stock or a bond, but still may qualify as a security. We handle these misrepresentation and omission claims. We also have claims related to investments that we handle based on negligence and mismanagement of the business. And then also we look at broker and advisor liability. It's not only the person who's running the company or selling the investment that faces liability in instances like this. A lot of times there will be a broker or an advisor who notified their client about the investment first and brought it to their attention. If it's something that's not suitable for the investor, or if it's a financial advisor, if it's not in the investor's best interest, then there can definitely be liability on the broker or advisor. Oftentimes, that's going to end up in arbitration, which means you have to make sure that the claim is really worth it to submit it to arbitration. Ideally, we like to do mostly class actions here, but if there's enough of a claim, enough substance to it, and the damages are enough, we do take some FINRA arbitration matters. Class actions will not go to FINRA arbitration. FINRA arbitration rules specifically exclude class actions, so those have to go to court. Individual investors and even groups of investors, if it's a broker-dealer that you're filing against, you'll end up in FINRA arbitration. But if you're going directly against either the people who committed the fraud, the companies that they control, and even some other parties that may have aided in the fraud, you can take those individual investors or groups of investors straight to court and not have to worry about arbitration unless it's contained somewhere in the agreements. And then there may be ways around that if the agreement itself was, there was fraud in the inducement to get them to sign the agreement. So each state, beyond the federal securities laws, each state has what are called blue sky laws. These are the state's policing of securities offerings. There are variations in between them, but they're all pretty well similar in terms of what they cover against, which is, again, misrepresentations or omissions in connection with the sale of a security. And that security can be sold into, within, or from the state, and you can have jurisdiction. So say you have an Alabama investor who purchases security from somebody who's pitching it, and the company is located in Georgia. You could have jurisdiction in Georgia because they sold the security out of Georgia, but you could also have jurisdiction in Alabama because the promotional material was sent into Alabama and the investor sent their money from there. So you have a couple of different ways that you can get jurisdiction kind of where you want it or where you need it. If a security isn't registered with the state, then you almost always have an automatic violation of state securities laws. There's different rules on whether failure to register alone qualifies as a material misrepresentation or omission. And it's usually not something that's good to travel under. What you want to have is something that falls under the anti-fraud provisions of the blue sky laws. Know too, though, that when it's a covered security, that is something traded on a national exchange, like on the New York Stock Exchange, and you're talking about a class action, which would be a covered class action is more than 50 people, that's something that will have to be brought in federal court and almost always will have to be pursuant to federal law. So the Alabama Securities Act, I've worked a lot with this one area of the Code of Alabama for 5 years of my career. So it covers all securities regulation for the state of Alabama, plus a few regulations that were enacted by the Securities Commission as they're authorized by the Act. 8617 covers what is a violation of the Act. And Again, it's unlawful for any person in connection with the offer, sale, or purchase of any security, directly or indirectly, to employ a device, scheme, or artifice to defraud, make an untrue statement of material fact, or omit to state a material fact, or to engage in any act or practice or course of business which operates or would operate as a fraud or deceit upon any person. So those three different sections kind of have some overlap and interplay between them, but they give you a little bit of wiggle room with how you can argue it and how you can build a case, because it doesn't always just boil down to they made this one statement and this one material fact was either false or they omitted it. If the entire thing operates as a fraud, even though you can't pinpoint the precise misrepresentation or omission, these other two subsections kind of give you a little bit of leeway with how you can prove it. Civil liabilities under the Alabama Securities Act, and all states are in line with this or are pretty close to it. You can get back the purchase price of the security. You get interest at 6% a year from the date of payment, court costs, reasonable attorney's fees. And then you have to trade off, any income that was received on the security. This is common for every state. The interest rates will vary. I believe in Washington State, I think it may be 8%. In Texas's Securities Act, the interest rate is just stated as what the legal rate of interest is at the time of the purchase, which is controlled by a different part of the code in Texas. So you can usually know that any action, you'll be able to at least get back the price they paid minus income that they received on it, plus the interest, plus costs and fees. Some other states also specifically include not just court costs, but costs of litigation, which would also cover things like expert fees and things like that. Control person liability is another big one, and that also appears in almost all blue sky laws that I know of for every state. Any person who directly or indirectly controls a person liable is equally as liable for the securities fraud violations. This includes partners, officers, and directors of a company. So that means if you have an investment fraud activity that one person at a company is committing within the scope of their employment at this company, then the directors and officers of that company can be held liable as well. And often getting to directors and officers opens up additional insurance that could be implicated in a judgment or in a potential settlement. So it gives you better leverage in the case, and is important too, because that provision exists to make sure that companies adequately control people under them who are engaging in securities transactions. We've filed a case recently, and the SEC actually has an action going right now too, related to Clean Energy Technology Association Incorporated. This was a company in Texas that promoted itself as doing all sorts of alternative clean energy projects. The latest one that they did was related to carbon capture units. Roy Hill is a Texas attorney, founded the company. He owned patents for equipment and a method of doing what he called coal distillation, which they would take dirty coal that people couldn't use due to environmental regulations, treat it with some type of a chemical, and turn it into cleaner burning coal, and then have a solvent left over that could be used for other purposes in the oil and gas industry. In 2019, he started offering carbon capture unit investments, and the carbon capture units were intended to be put on natural gas pipelines and trap CO2 using his solution from the coal distillation, and then they could sell that for use in the oil and gas industry, and people would pay them money for this carbon capture. That was the pitch. He said that all of this was patented, but it wasn't. He said that he leased these units to oil and gas producers, but he didn't. He said he had that this Cetasol, which is the fluid that was left over, could be used in fracking, but it wasn't. He said he had a contract with Exxon, but it wasn't. He promised returns of 10% per quarter, totaling about 40% per year. So the returns were really high. Eric Shelley comes into the picture because, as you saw in the last slide, I skipped before I mentioned it, the cost of these units was about $1.5 million. Well, most people don't have that lying around to purchase a carbon capture unit. So Eric Shelley would create investment feeder funds, and he would pool together multiple people's money to purchase 2 or 3 units at a time so that people could get in for $100,000 instead of 1.5. He worked with Hill and CETA to create these funds and ended up selling hundreds of millions of dollars to investors all over the country. Some of the investors who didn't want to pay the fees that Shelley would take for his funds started looking for financing and connected with Eubank, which is a state chartered bank in Linwood, Washington. This is who we filed our lawsuit against. Eubank specializes in SBA loans and provided 12 SBA 7A loans to investors to purchase these CCUs. They worked with CETA and FIC, Freedom Impact Consulting, to alter investment documents like business plans, operating agreements, and even altered financial projections, completed all the paperwork for the clients, submitted it to them for their signature, and then forwarded it to the SBA. And they had, in their due diligence period, tried to get information from CETA, like audited financials, bank statements, and to see the contract, but CETA never would give it to them. So in May 2023, remember they started selling these in 2019. May 2023, the SEC files a complaint, a request for a TRO, and an asset freeze. On May 8th, that was granted. All of CETA's assets were frozen and the filings were unsealed. And at that point in time is when every investor found out that they'd been a victim of this fraud. Also, importantly, for our clients in the Eubank case, that's when all of their payments stopped, which greatly impacted their ability to make their loan payments. According to the receiver's report, CETA took in over $240 million from 400 investors. They're in just about every state in the country. As you can see on there, like I mentioned earlier, no contract with Exxon, no patents. And all of the income was coming from investors, which means all of the payments going out to investors was new investor money. And bonus points if you recognize whose picture is on that slide. Our complaints in the Western District of Washington, those 12 loans were issued to 15 investors. The defendants are Eubank, their parent company, UNI Financial, and the directors and officers. And those directors and officers have the suit against them under that control theory that I noted earlier. We have fraud and negligence claims, as well as violations of the Washington Securities Act and the Washington Consumer Protection Act. We also have a RICO claim in there. And one thing that's notable, if you see any of these cases come through your door, is that RICO has a very specific requirement that if it's based upon a securities violation, there has to be a criminal conviction first before you can proceed under RICO for a securities violation. So that's notable. I don't think I have enough time to get through all of this, but I will say, normally, what we've come into in this one, normally a bank doesn't owe a duty besides just a duty of good faith. But if they take on extra responsibilities or do something beyond just furnishing money, a lot of times you can have a duty imposed upon them that normally wouldn't be there. So when looking at these cases, try to look for something like that, somewhere they go above and beyond. And obviously, what we look for is someone at the end of the case where you could actually get a judgment satisfied. CETA and Roy Hill are going to lose everything that they have to the SEC and the receivership. So there's not really much of a point of just pursuing them because you can't get blood from a stone. But if other people aided them in the fraud and have either assets or insurance to cover their liability, it's a great way to still try and get money back for those victims who possibly lost a portion of their life savings that they don't have time to make up anymore.
All right. Well, on behalf of all our viewers, I want to thank James and Mitch for a fantastic presentation. I am going to take a stab at that bonus question. I think that is Mr. Ponzi, if I'm not mistaken.
Charles Ponzi, yes.
There we go. Charles Ponzi. Well, I'm always amazed by the work that my partners do. I really enjoy learning from them. We have received a question from one of our viewers today, and that question comes from Kelsey. Kelsey asks, is there a requirement that a plaintiff injured by an auto defect still have the vehicle in their possession when filing? And I'm going to pitch that one to you, Mitch.
You're muted.
Sorry about that. That's a good question, Kelsey. So I'm going to answer in the context of economic loss class actions, which this is, not in the sense of personal injury, product liability defects, but in terms of the economic loss auto class actions. From a substantive damages standpoint, no, it doesn't matter because you're damaged at the point of sale. You still paid more for a product than you would have. However, from a practical spoliation standpoint, we run into this a good bit. If they got rid of their vehicle without the defendant being able to inspect it, as well as other documents, that could cause a spoliation issue down the road. So the answer is yes and no.
All right, fantastic. So we have one more question that's come in. This one's from Graham. He says, regarding the criminal conviction requirement to bring a RICO securities class action, is the relevant statute of limitation told until the criminal conviction is secured? James, do you want to take that one?
Yeah, I can take that one and answer it pretty quickly. I don't know. I'm not sure of the answer to that. We are traveling in this case under alternative theories, which is why we brought the Washington State Securities Act claim and the RICO claim. And, you know, we even in the complaint state that these are alternative because we realize that you can't have the RICO violation based upon action that hasn't sustained a conviction yet. Yeah, I wouldn't want to venture to guess on it because I haven't traveled that far down the research on that road yet.
Right. Well, we're just about out of time, but for those of you who may have missed our earlier announcements, by the end of this week, you're going to receive an email with a certificate of attendance and an updated presentation and video link, and you can email that completed evaluation form to webinars@beasleyallen.com. Again, for those Alabama and Georgia attorneys participating by phone, it's really important that you email us your name, phone number, and state bar ID number. Send that to webinars@beasleyallen.com. That's going to help us ensure you receive full CLE credit. Be sure to check out the events page of our website, beasleyallen.com/events, as we're going to be adding some really exciting webinars throughout the remainder of this year. Hey, thanks to all of you for joining us today. Thank you so much for supporting our Beasley Allen webinar series. Have a great day.